Hello, and welcome to The Verdict is In, where we'll be thinking about the use of machine learning to predict outcomes in court. My name is Abdelaziz Nasser Bahnasi. I'm a student in Professor Goodman's prediction class this semester with my TF, Harshal. In this semester, we've talked a lot about domains of prediction broadly, right? We've begun to understand the predictive framework as it applies to climate, as it applies to the economy, as it applies to personal health and well-being and genomics, and also even the coronavirus, which is the ongoing pandemic, right? The court is an interesting location for predictions. Not only does the court matter significantly to the average person in the United States with regards to being a core fundamental constitutional right, but it very much affects people's livelihood, right? With regards to making sure people are treated justly by the government. It keeps people out of jail if they don't deserve to be in jail. It keeps people accountable in terms of holding up the law, right? But it also ensures that each citizen has a right to express, at least the court specifically, gives them the right to express their defense with regards to accusations by other people. So let's get right into it. Rather than going straight into prediction, we'll think about first what the court actually is, right? What kind of legal system do we have? Then we'll go into a history of prediction within the legal system. Then we'll delve into uncertainty, and then we'll go into the predictive framework itself. Historically speaking, there are two types of law categorically. The first is common law, and the second is civil law. Common law originated in England in approximately 12 to 1300, right, the Middle Ages. Civil law originated in 7th century Rome, and it was spread by the French and also the Spanish to most places in the world. There's a key differentiator between the two. Common law uses case law, or historical precedents, to determine verdicts and sentences, whereas civil law is simply the application of statutes. Under civil law, the judge applies the statutes that are in the law and cross-references what the person did to determine the verdict and the sentence. Under case law, which is the system of common law, the judge or the jury uses historical precedent to understand what is the most likely response, correct response to what this person did, right? So here's an illustration. Civil law has a defendant and a judge. The judge simply says, okay, we have X and Y pieces of evidence, which according to these statutes makes this person guilty. Under common law, the defendant has a jury. In the United States specifically, the person is entitled to a jury of their peers. We'll get to that in a second, but the idea is the system uses historical precedent. X plus Y is the question. What does X plus Y mean, right? Like we have these two pieces of evidence, and what does that actually entail in terms of a sentence, in terms of a verdict? We know that last year there was a court case, a trial. There was X plus Z evidence. Z is very similar to Y. That resulted in guilty. That was the verdict. Therefore, using historical precedent and the similarity between Y and Z, we can say that X plus Y produces a guilty verdict. Now, the way the jury actually works is it's a subsample. It's supposed to be a representative, random sample of the population. The idea of a jury of your peers is supposed to mean that there is no intrinsic bias to the group of people that are giving you your judgment, right? Now, we're going to get into why that doesn't actually work in a second, but fundamentally speaking, the jury represents a sample of the population, so that America is judging the defendant, more so than any specific group of people. Here's a history of predictions in the court, at least in the most recent period. In the early 1990s, there was a wave of publication of the earliest modern data sets, the data we can use today for prediction. In 2000, the notion of predicting verdicts became formalized through academic papers. This is when the academic literature began to flourish. From 2000 to approximately 2015, the social sciences began to understand the kinds of biases that produce verdicts, or variation in verdicts at the very least. Now, natural language processing has also evolved over this period, and it's evolved a lot more ever since. In the most recent period, we've had a lot more data. People have tried and tested machine learning and actually applied it for court decisions. It's a field called legal tech, and the goal is now to increase accuracy of predictions. In reality, the history of predictions goes back way longer. Here we are today, right? Everything on the last slide belongs over here, but the history stretches back to 600 CE, with the formalization of civil law, wherein the system didn't require discretion by the judge, but there was a legal system in which people had to go to court and likely mentally made predictions about what would happen, or the judge in the determination of what would happen could make a prediction. More formally and more interestingly, in the Middle Ages, when common law begins to exist in Britain, the use of precedents and discretion in ruling allows for lawyers to represent clients. Lawyers definitionally make predictions. They represent their client in the most just way possible, right? That's their goal, that's their job. But in the process, they have to understand what the other side will say. They have to understand what the judge will feel or the jury will feel, and they have to understand their client's interaction with all of those decisions. And in the period ever since, America has developed its own system of precedents, right? So you can't just rely on another country's precedents. If you develop your own laws, it takes time to develop your own history of precedents, and that's what's happened in the United States ever since. Now, there are a number of statistics about what prediction actually produces today. And there are some esoteric examples. There are large examples, the Supreme Court of the United States on the left and the European Court for Human Rights on the right. The right is ironic, right? No, but anyway, there are a number of papers on making predictions in the Supreme Court that say accuracy is around 70% in terms of determining Supreme Court decisions on a given topic, right? Now, in the European Court of Human Rights, which is actually a civil law system, the accuracy is around 75%, which kind of illustrates that civil law is a little bit more predictable because it doesn't have a discretionary system. Now, what's actually happening here? Um, in each of these cases, I will say I'll get to this in a second actually, but the fundamental idea is that these are baselines. There's a caveat here in that cross-court predictions are probably going to be less accurate. People have used individual idiosyncratic data for each of these courts to make predictions about what those justices or jurors or judges will say about a future case, which makes a lot of sense if you have enough of that data, right? If you know that these people, or the tradition of these people, or the precedents that they're going to be using, has led to a specific framework for making decisions about a case, you can more easily make predictions about that same exact court moving forward, right? Which applies to the Supreme Court, which has a lot of data, centuries worth of data, and which applies to the European Court of Human Rights as well. Now, here's the caveat again. Cross-court predictions, meaning trying to make predictions irrespective of the court you're going to be using, likely will be a little bit less accurate. What are the reasons for that? The reason essentially is because idiosyncratic variation or biases or irrationality, which would drive uncertainty in any case, right? Let's explain that actually before we get onto this. Idiosyncratic biases are the driver of uncertainty. In that, uncertainty is any deviation from the predicted ruling or the predicted verdict, right? And if we assume that that's going to be just or perfectly in line with historical precedents, then any divergence or deviation would be some kind of idiosyncratic variation, right? According to whichever court you're looking at, or whichever group of jurors you're looking at, or judges, right? Now, that's actually the reason that the 70% is lower than the 75%, because the discretion allows for that idiosyncratic piece a little bit more. But anyway, getting back to the fact that there is this level of variation that we can't actually capture in cross-court predictions. When we're looking at a single court, those biases are baked into the prediction, and so any prediction we make uses those biases correctly, right? Whereas across courts, each of the levels of biases differs, and so predictions are likely to be less accurate in aggregate, right? At the same time, nobody's really done what we're suggesting across courts in the American context. So these numbers are nothing more than baselines at the moment. What are the sources of uncertainty? We talked about biases broadly, right? But everything kind of falls under this bucket of human irrationality. If humans were perfectly rational and we had a predictive framework, we would predict everything correctly every time. But that's not the case. Why is that? Well, because human beings, idiosyncratically, right, independently, behave differently in different circumstances and given different evidence. So there are three branches of this irrationality. The first is bias in terms of the racial, religious, gender composition, and even ideological composition of a jury. A second is Bayesian inference. There's a cool paper published in the early 2000s about it's called the jury observation fallacy, which basically says that human beings, observers of a court, are irrational when it comes to updating their prior beliefs about a conviction. I'll explain a little bit more in a second as well. But the third piece of irrationality is interpersonal, wherein literally members of the jury or a judge toward parties of the court give off symbols or signals or dominate the conversation in certain ways that end up skewing the result in a certain direction. And there's actually an empirical literature that's starting to explore this a little bit more. Going back to Bayesian inference for a second, there's this vignette. It's a story that basically, if you tell people that somebody was convicted before this trial, after they've already voted non-guilty on this person, they would say, oh, we doubt what the jury decided. The jury, taking this new information that the person was previously convicted, should actually have said that this person is guilty, or should have been less convinced about the non-guilty part, right? Not guilty. The problem is using actual Bayesian inference in terms of updating your priors. The person's previous conviction leads to a less likely guilty outcome. And so human beings don't actually rationalize that perfectly. This is a very brief explanation. If you want to go more into it, there is a link in the write-up that would lead you to the paper. Now, let's get to the actual prediction framework or predictive framework. We have a number of objectives here, right? And there are two layers to it broadly. The first is the jury's verdict, and the second is the judge's sentence. The jury's verdict is the guilty or not guilty decision, right? The judge's sentence is, given that verdict, what are we assigning this person as a punishment? Or whether it's jail time, or a fee, or some kind of fine, right? Now, under the jury's verdict, there actually are two pieces as well. The first is predicting what a selected jury will rule, and the second is deciding on a just verdict. So the first is using a normal classification algorithm using historical data and producing an outcome that's based entirely on that historical data. The second, the just verdict, is an attempt to debias that data, to debias that outcome. So here's a little bit more of a delve into the framework. If we look on the jury's side, here we have the predict guilty or not guilty given the contents of the case. In this case, we're using natural language processing and a classification algorithm to look at historical inputs, which are publications about cases, right? Case write-ups. And we're producing an outcome, guilty or not guilty, right? And so we start to understand what evidence leads to a guilty or non-guilty prediction or outcome in a given case, right? Now, again, this doesn't explicitly weed out bias, right? In that the jury might be made up of people with a specific racial composition or gender composition, and there's abundant evidence that tells us that those things matter, right? So it's actually, those are endogenous to this prediction, and it's possible to amplify them with regards to, okay, if we have a jury that's going to look more of this composition, like, can we actually amplify that bias, right? If we refine that prediction to account for biases, we end up with the more just verdict. On the judge's side, we predict the sentence given the set of charges, right? The jury's verdict on those charges, uniformity of historical sentences, right? Like, is this something that changes with each case, or is it something that's pretty standard? That's a factor that you can put into the classification algorithm. And then also the key details of the case. So there's a piece of natural language processing here as well. Now, the most interesting thing, at least in my opinion, about this entire situation is that case law, with regards to using historical precedents, is the perfect natural framework for classification, because classification is exactly the same thing. Classification is the use of factors historically and mapping them to an outcome. Judges are doing the exact same thing. They're using historical inputs and predicting their outputs. That's the role of historical precedents in case law, which makes this entire problem very easy and interesting to think about. How do we evaluate accuracy in this predictive framework? For each of these predictions, we train and test on historical data, right, to determine the accuracy of the model. So we have a bunch of data, a bunch of court filings, a bunch of basic facts about the cases that we label with regards to the factor categories. We have the label for the outcome, right, for the case, and we can talk a little bit more about how to amplify this in a second. But if we train and test, we end up getting a value for uncertainty based on our prediction accuracy for the testing portion of the data, right? Now, you can also reevaluate the model's accuracy at each step and then update the algorithm based on whether or not there are biases that are baked in at each step, right? Based on temporal or geographic or jury composition-based biases, right? We would then apply this algorithm to any new cases to make predictions about future verdicts, and then we recalibrate our accuracy continuously thereafter. So before we get onto the communication piece, we can amplify uncertainty, or at least decrease uncertainty, in a couple different ways. There are 3 ways in particular. The first is to understand, more fundamentally, people's rationale and decision-making process on the jury, right? So we talked a lot about the racial composition, the gender composition, the ideological composition. There are also peer effects, network effects. We talked about this earlier when we were talking about the interpersonal irrationality, wherein if a judge nods or shakes her head towards a party in the court, you can kind of determine that there is an effect empirically on the outcome. So understanding people's incentives, understanding people's interpersonal relationships, and whether or not there are effects or power dynamics in some way would go a long way in trying to quantify those biases so that we can reweight the algorithm continuously, right? The second way to reduce uncertainty is to feed more rigorous data into the training set. So just more data, right? We talked about the fact that the Supreme Court and the European Court for Human Rights have a lot of data, which makes it very easy to look at those courts in particular. However, there are options that don't rely on real history. Although there are ethical considerations here as well, what you could do, you could create mock trials with mock juries. You could feed them hypothetical information, hypothetical cases, and have them decide on a verdict. And you can record that data as training data, right? An alternative is to use lawyers. Create a panel of lawyers, have them evaluate a sentence, right, or a settlement if it's going to be a fine in a civil case, and use that as training data as well. In fact, that's with precedents. This happens in Michigan, for example, where the Michigan state courts require before trial that the parties go to a panel of lawyers to receive an estimate for the settlement that they could use or that they could agree on before going to trial. And so courts rely on lawyers' expertise to do so, right? So if you have mechanical understanding of the law through this expertise, then you can create very accurate, just outcomes in the training data, right? Which would give you a lot of rigorous data as well. Now, the third piece with regards to reducing uncertainty is to segment cases by domain of the law or by court, right? Again, we saw this with the Supreme Court and the European Court for Human Rights. We saw that if you have a specific idiosyncratic court, it becomes a lot easier, or at least we hypothesized this, to make predictions because it's the same people who are making the decisions. It's the same general area of life that gives those cases to that court, right? So the human rights domain for the European Court, right? Or the decisions that are federal, and so a little bit more clear to think about versus locally distinct issues with regards to the Supreme Court. And the other piece, again, is to segment by domain type, right? So divorce alimonies, for example, might be very predictable. So you might want to lessen the amount of training data you have with regards to divorce alimonies, and you might want to actually use a smaller amount of that training to make predictions reasonably well, which would allow us to add rigor given a fixed amount of resources by allocating those resources to areas that might require more training data. Now, communicating this uncertainty to the public is really important, right? Because court cases, again, not only are fundamentally important to the average American person, but they're also a big deal to the public. And the public understands that there are biases. Remember the O.J. Simpson case in the 1990s? I wasn't born yet, but I've heard a lot about it. I might have been born. I don't remember. I was born in 1999. Regardless, the public was in disarray. They were divided on this issue. Some people were convinced that he did it. Some people were convinced that he didn't. Some people were convinced that the jury was biased. Others were convinced that it wasn't, right? Now, there's this general understanding that there are biases. However, the public does not understand the magnitude of those biases or of the irrationality that drives the uncertainty in verdicts, right? Why is it that the day of the trial, we didn't know what was going to happen? Should that be the case? Is that actually truly what justice should look like, right? Now, the value add to the American system, if the public becomes engaged with court predictions, is that we hold courts accountable. Instead of allowing for the idiosyncratic uncertainty that comes with specific juries, that comes with specific circumstantial pieces comes with specific circumstances, we could instead have people predict a public prediction, a public conviction, a public verdict, which would then be the aggregate correct verdict that would update people's prior beliefs before going into the jury, right? And so instead of functioning from wildly variant and different public beliefs, prior beliefs, people would instead have some baseline that is in aggregate, average, in terms of an average, correct. And so we would, in a way, refine the justice system, right? The approach to future communication would be really simple. You explain the court system, you teach it in schools in a way that makes people really understand what is going on, right? If you want data on litigation, there are ways to get that data and to teach it to younger people. The second is to compile a list of factors of uncertainty or variation, right? So understanding what racial bias looks like in terms of a percentage effect on an outcome, for example, or the pure effects, right? The third is to create an interactive platform that allows people to predict these outcomes given their selected inputs for a case. There are a number of websites and pieces of software that actually allow you to put in information about your case to make a prediction about what's going to happen. Now, what happens if we actually create this on a public scale? What happens if we create some kind of prediction market wherein people give their opinions and we end up with, in terms of laws of large numbers and also accuracy of the masses, we end up with a more concrete understanding of what a debiased prediction would look like, a debiased outcome would look like. That's kind of the end of the presentation. It's been a long presentation. I'm really sorry. Here's a list of data that could go into the classification algorithm, the training data. Why is any of this important? It would help us feed back into which kinds of juries we look at, right? If we understand more about the biases and uncertainty, it could prevent the irrational rule in terms of allowing us to advise people on the jury and about their natural irrationality, for example, the jury observation fallacy. And the third is to ensure justice in the judicial system more broadly, right? Again, if people are more engaged, if people understand what's happening in a court, there is less of an opportunity for idiosyncratic uncertainty and irrationality to take over. And so we would end up in a place where the outcome matches the prediction, for better or worse. Although that's never going to be 100% correct, because there is discretion inherent to the common law system, it would allow us to get to a place where that discretion is based fundamentally and solely on the difference in circumstances and evidence from the historical precedents, instead of in addition to or in combination with the biases and irrationality that currently accompany it. Thank you for your patience and time. I understand this was a long, long presentation. Hopefully you can read the write-up and let me know what you think.